he was an inventor or researcher like you and me in University of California. And he invented a web browser that supported plugins, streaming media, and cloud computing. And he was intelligent enough and he was aware of importance of patents. That's why he filed patent application in 1990s. And you know what happened next? He found that Microsoft, which is one of the biggest companies in the world, is using his patent protected technology. And that is why Michael Doyle reached to Microsoft for licensing, but Microsoft denied. And not only Microsoft, there were other companies as well, but we are discussing Microsoft in this case. And because of this, Michael Doyle reached to US court and filed suit against Microsoft. And in return, he was awarded damages of $521 million. That's the power of patents. So as you can understand that, he could have simply worked on his platform, he could have improvised it, maybe, adding more features, making sure that it is user-friendly. But since he actually took out time and he was aware of patents, that is why he earned such a huge amount of money. I mean, he might not have earned such a huge amount of money just by working on his product, right? Next, Michael Doyle could be you, but only and only if you protect your idea today. Because if you do not protect your idea today, then, in future, you might regret that I could have done that, but now I have lost the opportunity, right? Okay. So moving on to discuss briefly about, what are patents. I believe that, you are already aware of this, but just wanted to give you, brief introduction about patents, and then we will move on to the drafting and filing part. So what are patents? Patents is a legal right that is given to a person over creation of his or her mind, and it is used to prevent others from making, using, offering for sale, selling, or importing the invention. So for example, whenever you build a house, what do? You actually try to create a boundary around your house to say that this is my house, this is my property, I have the right on it. Nobody else is supposed to do anything with it without my permission or without giving money to me, right? Similarly, patents are also used to create boundary around your innovation, to say that inside this boundary, this is my property. I have the right on it. Nobody else is supposed to do anything with it without my permission or without giving royalty to me, right? So let me try to give you some examples in order to explain it in a better way. You can think of a recommendation engine which recommends similar products to a user. It can be on the basis of anything, right? It can be on the basis of location of the user, maybe based on age of the user, searching history of the user, anything, right? You can also think of a recommendation engine that recommends a specific route in going from position A to position B. Again, that could be based on anything, right? Think of a social media platform that provides ads based on user profile or other parameters. Think of autonomous vehicles that's so much in news nowadays, right? Think of any web camera, any features of the application that is running on your phone or measuring tool. These are some of the examples which can be patented, or they're already being patented. It's just that, what I'm trying to say is that, in order to protect the functionality of the technology, we have to go for patents, okay? We will also look at the difference between patents and other IPR forms in subsequent slides, but as of now, we are focusing on patents, okay? Moving on to understand why do we need to register a patent, although I have discussed this point in the previous slides, but since this was the top most important topic of the day, that is why I would like to discuss about this. So the first reason of registering a patent is to stop anyone from copying your idea. right? Of course, because that's your idea. It's your hard work. You do not want others to steal it just like that, right? That is why patents are required. Secondly, you can also think of patents as a source of revenue, like we have seen in case of Michael Doyle, that how much money he earned out of this. So you can also think of it as a source of revenue if you also want to license it, or you actually found that somebody's using it. Another reason for filing a patent is that in order to gain marketing edge and credibility. So, you might have seen in case of various FMCG products that they actually write, patent number on the product, or they actually use the tag patent pending. You know why they do so? This is just to gain trust of the customer, to say that we have applied or we have got a patent. So that is why the technology of this product is new and the quality of this product might be better than rest of the products lying there, right? So that is why patents are used to gain trust of the customer. Another very important reason for filing a patent application is to increase valuation of your company. So, I was in discussion with lots of startups, and one of the main reasons for filing a patent application is that they want to increase valuation of the company. So it can be 2 times, 3 times, 10 times, that depends upon number of factors. But because, whenever they reach out to any investors, they also ask this question, whether your idea is patent protected or not. Of course, because, they also want to invest in a idea or company whose idea is patent protected, so that nobody can enter their domain easily, right? So these are some of the reasons why patents are filed. It is not that reasons are limited only to these 4 things, but these are the topmost points. Okay. With that, let's take a quick break to understand how much we have learned today. So you can use, you can write your answers in the chat box, and please try to answer this. So the question is, filing a patent gives you the right to manufacture your product. Option number 1, true. Option number 2, false. Please share your answers. Even if it is wrong, it is perfectly fine. Just try. Thank you for sharing the answers. So actually, the correct answer is option number 2. That's false. So let me try to give answers to this. So this is a pen, okay? If I have to manufacture this pen, do you think that I need to file a patent application to manufacture this pen? No, right? I can simply start manufacturing this pen. I don't have to file a patent application for this. The only thing that I have to take care is that if I have to manufacture this pen in India, I have to make sure that no other company or individual have got a patent in India on this pen. If they have got a patent on this pen, then I cannot manufacture this in India because I'm violating someone else's right. But if I have to, manufacture this pen and there are no patents around it, I can manufacture it. It's not that I need to file a patent application. I can file, but it is not mandatory. Okay, thank you. So with that, we'll move. So let me just try to give you the process, share the process of obtaining a patent in India, because that's very important. Because it's not a very straightforward process. It's not like a company registration where you apply for a company registration and it will be done in a week or two, but it's a little lengthy process. So the step number one, although this step is optional, but it is highly recommended one. Okay, this is because patents are granted when the application is new. Okay, when the idea is unique. So that means it should not be disclosed or published by anyone else in the world, not just India. Okay. Secondly, it should not be obvious. So it should not happen that, from one application, we are taking out one feature, and from another application, we are taking out another feature, and we are simply aggregating the two. Because in that case, examiner would reject the patent application to say that, you have not applied any inventive step here, and that is why this was not patentable. Okay, so in this step, what we do is that before actually we draft a patent application or file a patent application, we conduct a search to check whether this idea is disclosed by anyone else in the world. Okay, so based on this, we draft the patent application. We modify the scope of patent application. We know what is actually the novel concept or novel feature in this. Okay, so that is why this is highly recommended step. Now moving on to step number 2, that is drafting and filing the patent application. So let me just try to give you a brief understanding about this, but we'll talk about this in detail. So patent is a techno-legal document. So that means, a person who is writing the patent application need to have technical expertise. Of course, you should have the technical expertise. In addition to that, legal expertise is also required. So even you can also draft a patent application by your own, but the only thing is that you, of course, have the technical expertise because that's your invention, but you might not have the, legal expertise. And because of that, the boundary that you will create around your innovation will be narrow. And because of that, the commercial value of patent would be low, right? That is why it is highly recommended to hire a patent agent or attorney like me to get a patent on your invention. Okay. Once a patent application is drafted, we need to file the patent application. And patents are territorial. So that means you have to decide in which countries you want to get the protection, and based on that, you file the patent application there. So for example, if you want to protect your idea in India only, then we will file the patent application at Indian Patent Office. But if you want to get the protection, let's say in US as well, we need to file the patent application in US as well. So it is not that, you file the patent application in India and you get worldwide protection. So that is, it doesn't work like that. Okay. So once a patent application is filed, it moves to step number 3. In this, once a patent is filed, it is published after 18 months of the filing the patent application. So that's the usual process. But if you want, you can also go for early publication by raising a specific request, and your patent will be published within 1 or 2 months. Okay. So it's generally 1 month. It's actually less than that, but on the safer side, it is, you can say 1 to 2 months. So that means your patent application will come in the public domain. Anyone can see that. Okay, publication means it is coming in the public domain, and anyone can see that you have filed or applied for a patent application. Okay. Once a patent is published, then it will enter the queue for examination. So in this phase, the examiner would look at your patent application to see whether this idea is new or not, whether this idea is obvious or not, whether this idea is clear or not. And based on that, he will give his examination report, and we need to respond to those examination report in order to get a grant. Okay. If the examiner is convinced with our explanation, then he may grant the patent application, or he may refuse the patent application as well. Okay. I hope this is clear. Now moving on to discuss the timelines of patent process, because I've talked about the process, but let me give you just about the time. So let's say there are actually two types of patent applications. So one is the provisional application. So as the name suggests, it's you can say preliminary or placeholder. So whenever you have the basic idea ready, you need some time to go for the regular patent application, or you need time to evolve your idea. Then in that case, you can go for the provisional application. If you go for this, then you will have 12 months of time period to go for and apply the non-provisional patent application. Okay, so this timeline is very important, because even if we miss by one day, we cannot get the benefit of the provisional application. Okay, so the protection will start from the day of filing the provisional application. So whatever you have mentioned in the provisional application, on that part, you will start getting the protection from day one. Okay. Once a non-provisional application is filed, it is generally published after 18 months, as I mentioned. But if you want, you can go for early publication as well, right? Once a patent application is published, then it will enter the queue for examination, and examiner might grant the patent application as discussed. So the timeline to get a grant depends upon a lot of factors. So these are factors which are not really under our control. So that also includes backlog of Indian Patent Office and examiners, right? And conditions like coronavirus. So something which is not really under control, but you can say that on average, it is like 2 to 5 years from the date of filing the patent application, right? If you are not going through any expedited route, but there are provisions for going for expedited route as well. So there are certain categories. If you are falling under those categories, you can go for the expedited route. So in this case, your examination process would also expedite, like tatkal, right? So if you want to move faster with your patent application, you can go for the expedited route as well. Okay. So once a patent application is granted, it is alive for 20 years from the date of filing. Okay. And during this phase, you have to pay maintenance fees as well. Like you pay, maintenance fees for website. Similarly, you have to pay maintenance fees for patents as well in order to keep it alive. Okay, that was all about process. I hope this is clear. So just a quick question again. If I file a patent application in India, I get worldwide protection for my invention. Option number 1, true. Option number 2, false. I think this is very easy. So the correct answer is yes. The correct answer is false, because if I file a patent application in India, I get protection only in India, not worldwide. Okay. So if I want, protection in other countries as well, we need to file the patent application in other countries as well. Thank you. Now moving on to understand process of filing a patent application in India. I mean, now the details, what all are required while filing a patent application. Okay. So first of all, Indian Patent Office are located at 4 different places like Delhi, Kolkata, Mumbai, and Chennai. So based on your location or your company's location, appropriate office would be selected. Okay. And this is, automatically this would be selected. You don't have to worry about it. And it is like online, so everything would be taken care of them. And in case of non-resident, Indian resident, area of service of patent agent would be considered. Okay. So if you want to know more about your address of service, so or patent office branch which would be applicable for you, then this is a snapshot. So for example, for all states of Maharashtra, it is like Mumbai, and for all states, for the states of Haryana, sorry, it is New Delhi, right? For similarly for Karnataka, it is Chennai, and so on, right? So this is just about the territorial jurisdiction. Okay. Moving on, what all things are required, or what are the required documents to get to file a patent application. So in this particular case, for a patent, we need broadly, I'll keep the formalities aside, but the main things are that, we need the invention details, right? And what all it should include. So it should include the specification and abstract, drawings, claims. So let me take you through these.